Happy Friday. I've come fresh off the live stream of the 2-hour plus long Supreme Court oral argument on OSHA's ETS. If it says anything, there's a 3-cup of coffee kind of day, so please pardon any verbal typos, and I'll do my best to keep it concise and give you what you need to know. So as high-level background, if the Supreme Court does nothing, then starting on Monday, private employers with 100 or more employees will have to begin phase 1 of OSHA's ETS. What that means, having a policy in place. Again, this is not a simple policy. I've drafted one for clients. It took 10 hours to put it together. I'll link below a template you can use. So it has a lot of requirements. 2, to gather vaccination records for employees. 3, require compliant facial coverings for those employees that are not fully vaccinated. Phase 2 would start February 9th. That's the more controversial vaccine or testing requirement. So any employee that's not fully vaccinated, and that's just the 1 shot of Johnson & Johnson, 2 shots of Pfizer and Moderna, they have not cut up to boosters yet. If you're not fully vaccinated at that point, you need to get weekly testing. And prior blogs going through that. But the key point is Monday, a lot of employers are saying, what do I need to do? So today, the Supreme Court had their argument. So I want to give a high level of what could happen right now, and then I'll give the more interesting points. So legal observers, feel free to chime in. If you like trivia, fantastic. But let me tell you what you need to know. It seems possible that immediately, today, the Supreme Court could say at least do a short administrative stay. It's like a stay before stay, which means that they could say OSHA's rule will not come into effect until we have the chance to decide whether this is an emergency rule. What that means for employers is at least the Supreme Court might say that you don't have to do this Monday. They may issue their decision over the weekend, Monday, Tuesday, so it may just be a very short stay, but they did talk about this in oral argument to say, look, we get that this could be difficult for employers. What's the problem with having a short stay? Well, at least we can decide it. Because if that didn't happen, it's possible employers would start implementing all these policies Monday, and then Supreme Court could rule otherwise Monday, Tuesday, whenever. There was some discussion back and forth, but I think stay tuned. It's possible that there will be at least an administrative stay, which would give some certainty for employers if that were to be the case. Again, could give a couple-day reprieve. So stay tuned if that happens. The second is ultimately, how will the Supreme Court decide? Look, I say that Chief Justice John Roberts is like Ohio of the elections, or living in Atlanta. Maybe he's the Georgia of elections now. But a lot seems to depend on him because the court is very split. His questions went either way. He seemed to lend credence to both sides. So I truly believe it's a coin flip. I've put out there that my personal prediction is that the OSHA's ETS rule is upheld. They do not re-implement the stay, so employers do have to follow it. That is purely my guess. Again, I reserve the right to be totally wrong on this, but I predict to see a split decision, maybe 5-4. From the questions, I could see Justice Kagan leaking an opinion, perhaps John Roberts having a very short concurrence, very similar to the Sixth Circuit, where you saw that there was 3 judges, 2 decisions on each side. One was an Obama nominee, one was a Trump nominee. Those decisions were both very much pro or against the rule. And then it was the George W. Bush nominee that came squarely and said, look, maybe I don't like it, but I shouldn't say that, but maybe I don't. But this is within OSHA's authority. I could foresee Roberts saying that, but we will see. So today, watch to see if there's administrative stay entered. Otherwise, it sounds like the court is going to move very quickly. I've had a number of individuals ask, how long is it going to be before we know the Supreme Court? I sadly do not have a crystal ball, but I think we will know sooner rather than later. But I do hope for employers' sake that there is an administrative stay, so at least there is some certainty rather than potential implementing it Monday than if it was struck down. So we'll see. So getting to what happened today. So today there were 3 individuals that spoke. I'll have to say all 3 did a good job. So interestingly, so the 2 that spoke in order of at implementing the emergency stay, so striking down the emergency rule at least. One was Scott Keller, who appeared on behalf of business groups. The other was Flowers, who is the Ohio Solicitor General. And then Elizabeth Prelogar, I think I'm saying that right. She's the Solicitor General for the DOJ. She appeared on behalf of the government to defend the rule. And so all the judges then get the opportunity to ask questions. So a few of the more notable things that happened. COVID strikes the Supreme Court. So not knowing, I don't know if we know why, but Justice Sotomayor appeared via Zoom. There were some technical difficulties with her audio, as we can all appreciate, over the last couple years. Flowers from Ohio, he said although he's double vaccinated and has been boosted, he did contract COVID, so he appeared virtually as well. He actually cited that as part of this rule of why it's over-inclusive, to cite that he was able to contract it even though he's been vaccinated and boosted, because again, he's appearing for the governments that are looking to strike down this rule. Another interesting fact, so all three of those that appeared, they're no strangers to the Supreme Court. They all clerked for Supreme Court justices. So Keller was clerked for Justice Kennedy, Flowers for Scalia, and Proligar actually clerked for Justice Kagan, and Justice Ginsburg. So interesting to see that reunion. As I said earlier, Solicitor General Proligar, really interesting story. You can read about how she squared off in a mock trial against Justice Kavanaugh before he was on the Supreme Court. She was a Obama and Clinton supporter, not surprisingly working in Biden's White House. But interesting articles, how she's diametrically different in mindset from Justice Kavanaugh. So they had some good questions today. The big points that came across were who gets to decide. So really the crux of the Supreme Court deciding this, why are they deciding it, is the question, does OSHA have the right to issue this vaccine or testing mandate and mask requirement as an emergency rule? Breaking down that a little bit. I'll put this up in a second.
So this is a snippet of the OSHA Act of 1970, where Congress said the OSHA administrator could not require immunizations except where it was necessary. So question, is this necessary?
So you have the government, again, this is Solicitor General, they call her General Proligar, who points that Congress included the word immunizations in the OSHA Act for the authority that OSHA had. So they're saying, look, when OSHA finds something necessary, they have the right to enact a vaccine mandate like this. You then have the state government and business interests that say, look, this language is unclear whether this was 50 years ago, whether it actually applies to the vaccine mandate today. Congress could have spoken and states could have spoken. States should have the right to speak. Congress has not instituted a national vaccine or testing mandate or vaccine mandate, anything outside of OSHA's context. And so this is really just federal agencies trying to do a workaround. They also cite the emergency nature of this standard. Normally when OSHA or a government agency like this issues a rule, there's what's called a notice and comment period. That's when they do their research. They say, this is what we're thinking of. The public, meaning you or me, can write in and say, this is how I feel about it. They review all the responses and they edit the rule accordingly. In the emergency context, they don't have to do that. It's a shortened time period. They can issue the rule. So as you can imagine, there is a heightened standard. There's a more of a reasonableness decision for a normal agency rule. But here with the emergency standard, it has to truly be necessary. So there are a lot of questions around whether COVID is a grave danger to all workers, at least all workers for private employers of 100 or more employees. The sides saw differently on that, as you'd imagine, and whether this is necessary. So again, much like the arguments you saw in ultimately the decisions from the majority and dissenting Sixth Circuit courts, you have one side that says COVID has an impact. This is necessary to protect all workers. You then have especially the business groups that will say, look, if you want to address this, it should be more specific by industry. So look at factories where individuals are in close proximities, rather than other workplaces where workers may be able to stretch out, work socially distanced, and so there's no need for a mandate. Also saw the arguments from the business community saying, look, you have the potential risk to an unvaccinated 25-year-old is the same or less than a vaccinated 60-year-old in the workplace. So how does it make sense to have this rule that cuts across all ages, all industries? And so you're seeing real, not surprisingly to us in 2022, really strong opinions on each side. So that's the crux of it. What you kept seeing in the arguments today was the theme of who decides. Virtually every justice asked that and said that's the real question. And by who decides, they mean, does OSHA get to decide this standard? Or should it be that we have Congress that needs to be the one that decides, or the states that can each decide for themselves? And so ultimately you'll see that come down. So I wanted to provide that kind of summary. Really interesting arguments to listen to. I haven't listened to that many oral arguments at the Supreme Court, but what I, again, will be watching for today is an administrative stay issued. So is at least there a hold-off so employers wouldn't have the circumstance where they could enact policies and requirements Monday and potentially go against those Tuesday, Wednesday. So keep your eyes on that. And then ultimately how the Supreme Court decides, ostensibly in the next week or so or a few days, how it comes down. You've heard my prediction. We'll see. Again, I've been wrong before, but we'll see about that. And feel free to ask any questions. And I have a live tweet over at my manager_method Twitter account. So feel free to look over there for further details. Thanks.